Hi, my name is Morgan Richardson. I'm back again with another one of our classes about law this time. So, a little bit about myself. I'm an English teaching assistant at the university in Kazan, the Kazan Innovative University. Very excited to be here. Kazan is a wonderful city. The people are very friendly, a lot of sporty things going on, so I'm excited to live here, and I'm excited to talk to you about law. Before we get started, I will say I'm not a professionally trained lawyer, nor did I study law in school. However, this is a lesson about vocabulary, so I do have some basic information about law and things like that, but the lesson is primarily aimed at helping students to just gain vocabulary on the legal system. In particular, we will talk about the U.S. legal system. So, let's begin. First, we'll start off with, what is law? Very good question. So, what do you think law is? Well, according to the internet, law is a system of rules made by a government. So, what does this mean? These are rules to ensure that society functions, that people are safe, and that bad things don't happen, right? If people were good robots and they would just do what they were supposed to do, I guess we wouldn't need laws. But as you know, like I know, that's not the case. So, governments make laws. And when we talk about governments, I don't just mean federal governments. I also mean governments in a city, or even a university, or even in a town, right? So a government is just a body of people that oversee a society. So, laws help make sure people obey the rules. I mentioned that. Very important. But moreover, law holds the fabric of society together. So without them, people would really just do whatever they wanted to do. And we can't have that, can we? So, since law is a very complicated matter, most of this presentation will just focus on the basic principles of law. So I won't get into detail and things like that. I'll just give you the vocabulary you need in order to kind of begin a basic level discussion, an introductory level discussion about law. So, getting into more specifics, we have secular versus religious law. Now, what do you think secular law is? When you hear secular, what do you think? Secular essentially means the absence of religion. So, a good example of this is many legal systems in the world that are based on laws made by a human being or made by a group of human beings, such as the government. So, when we have secular law, these are changeable, right? So the main importance is that you can change them because humans make them. These laws do not really care so much about what people believe in, but rather if they're behaving properly or not. So, to be more specific, if I'm driving very fast down the road and I'm going over the speed limit, and a police officer pulled me over, rightfully so, I was driving too fast, he's going to tell me, you're driving too fast and now you're getting a speeding ticket. I'm getting a speeding ticket because I wasn't obeying the law, not because of how I was dressed or maybe my behavior from a while ago. It's the behavior that I'm doing in that moment. By contrast, we have religious law. Religious law is what it sounds like. It's law that is based upon, that is heavily influenced by religion. This is law that is not just concerned with how you behave, but also how you believe and what you think. So, I guess continuing with our example of me driving too fast on the road, which I should not have been doing in the first place, if I lived in a religious society, the police would stop me, the policeman would stop me, and he would probably say, you're driving too fast, but also, this is not what God or any other, religious figure would want you to be doing. This reflects badly upon your religious life as well. So that's a big difference. There is nothing wrong with religious or secular law. I have no opinions on that. This is just to talk about the two differences between major legal systems. Okay? So, moving on. Let's see. More information. So some countries that have secular legal systems include Brazil, Australia, India, and Nigeria. When we talk about these legal systems, secular means that when I break the law, there's a secular book of all the rules that I did not follow, apparently. When I go to see a judge, they have a secular book that tells me how I misbehaved. So there's no, God did not want you to do this. There's no, priest or religious person interpreting the law. It's just, you weren't supposed to be doing this, and this is the real life effect of that. By contrast, in a religious system, so oftentimes people that are upholders of justice, this excellent phrase, are also religious people. They're people that have special powers given to them by the god or gods that their society follows. So in a religious system, instead of seeing a judge, I would see a judge, but it's probably a religious person, so maybe a priest or someone like that. They would decide on my punishment, and most likely this punishment would affect you in life on earth and also life after death. So that's a big difference, is that religious systems, often your punishment could follow you. So be good, people. Don't be bad on, in secular or religious systems. Just follow the rules, guys. So, some countries with religious legal systems are Vatican City and Iran. So, kind of cool. Didn't know that. Okay. And of course, there are countries that are in between these two systems. So there are countries that are in between a secular and a religious system. What countries do you think these might be? Any guesses? I was actually quite surprised with the options here. So, some countries that are in between these two definitions of religious and secular are Argentina, England, and Israel. And I'll tell you why they're in between them. So, these countries have a secular legal system, but they have an official state religion. So in the case of England, they have the Anglican Church. That is the official religion. And as we all know, the Queen, Her Majesty, upholds, from what I understand, she kind of, she embodies God's will on earth, so to speak, something like that. So, but England has a secular legal system. So if you break the laws, you see a judge, things like that. But there's a legal system as well, or a religious system as well, that governs part of society. So, pretty cool. All right, let's get into more of America's legal system, and we'll talk about the history of it. So, to begin, everything in the U.S. came from England. I think it's quite obvious. America used to be a colony of England, so a lot of our traditions come from England. One very unique tradition is our legal system, and it is what is called a uncodified legal system. It's called a common law legal system. What does this mean? So, common law is different from civil law. And most countries, I believe, have a civil law system, especially most European countries. England is different, maybe because England's an island. I don't know. Could be something. But let's talk more about the differences between these common law and civil law systems. So, but before we get started, I will say there are parts of the U.S. that have aspects of a civil law system, and I'll explain why later on. So, according to the University of California at Berkeley School of Law, common law is typically uncodified, meaning there is no giant book of the legal system that a judge looks to when they're deciding a case. What is this? How does this work in reality? So I get caught speeding, and I disagree with the police officer. I think he or she was wrong. I want to go before a judge to go defend myself and to go explain why I'm right. Go to the judge. The judge doesn't have a giant book. They're not, okay, this is what happened, so this is what will happen to you. No, they interpret the situation in the moment. This is in an uncodified system. More specifically, in an uncodified system, precedent is extremely important. Precedent is relying on things that have happened in the past to influence present and future decisions. This is a very, very big deal in the U.S. legal system, and honestly, I'm surprised lawyers and judges and legal scholars can remember past legal rulings and all the precedents that went with them, but extremely important. A good example of a precedent, and precedent is just a good word to use in general. It doesn't just have to be used in a legal sense, so let's think of an example with precedent. So last summer was incredibly hot. I will use last summer as a precedent for this summer. So this summer will also probably be quite hot, right? So I'm using the past as a guide, as a source of information for the future. So precedent. Precedents are kept in court records so that judges can refer back to them when they make decisions. So it sounds like there's a big book, but it's not, quite as strictly you have to do this in this kind of instance. It's more so the judge interprets what happens, looks back at certain precedents and see if they apply, and if the precedent applies, and they'll use it in a ruling. So, what is the importance of this precedent, of this uncodified legal system? The importance is that in the U.S. and in English, so United Kingdom, legal tradition, is that judges have enormous power to shape American and British law. Why? Why do they have this power? They have this power because every time a judge sees a case, especially cases of national importance, right? So at the Supreme Court level, our highest court, they literally are changing how people can do things, how people cannot do things, how certain laws are interpreted, right? So every time a judge makes a ruling, that either reinforces or changes an existing legal structure. Now let's get some more about common law. Common law is an adversarial system, meaning it has adversaries, so people or groups fighting each other. And it's essentially a contest between two people. So this is kind of interesting. When you read it on paper, it sounds a little bit crazy, but this is how the legal system works. So a jury of citizens also is watching a case. So I'm in the courtroom talking to the judge, explaining why I don't need a ticket and how the police officer, she was wrong, she should not have arrested me, whatever. So depending on the seriousness of the case, there could be a jury. So a group of people, just random citizens, who watch the case and who are kind of like fact finders and help the judge out. The judge makes the final decision, but the jurors are there as well to make sure that a person has a fair trial. Okay? So, where did English law come from? So I'm talking a lot about what it is now, but as we all know, England is a very old country. Maybe not as old as many countries. This is of course true, but it has a very rich history of law as well. So let's talk about a little bit of that. So, at the beginning of the first millennia, so 1,000 years ago, medieval kings began to consolidate power in England, and they decided to make institutions in order to better rule their kingdoms. So, when you begin to make institutions, you need laws to govern these institutions, right? You can't just have all these different groups kind of working not in concert. You need some kind of unity, so to speak. So, the English crown, the king or queen, developed what is called a system of writs, or a highly specialized system of decisions for each wrong. So, similar to probably a codified system. However, there were so many writs that it became very difficult to apply justice in a fair manner. They ultimately decided to make courts of equity. Now, this is complicated, so I hope I am understanding and explaining this well. For you lawyers out there, please correct me. As I mentioned, I do not have official law training, so I hope I'm explaining this properly. So, a court of equity, according to the University of California, Berkeley School of Law, these courts were authorized to apply principles of equity based on many sources, including Roman and natural law, rather than apply only common law. So essentially, these were broken up courts that ruled different areas of life that were allowed to use different sources of law to find justice, to be more just. So a good example of this could be a criminal law system. This is actually a present-day court of equity that we have in the U.S. So this is, criminal law is separate from general law, and I suppose civil law as well. So yeah. Now let's talk about civil law. In contrast to common law, so the law system I've just spent the past couple minutes discussing, civil law is codified. What does this mean? Codified means that civil law systems have giant, continuously updated legal codes that judges have to abide by when they rule, when they decide in a case. So, such codes differentiate between categories of law, such as criminal, procedural, or penal. So they have, it sounds like they have more specific areas that they rule on, okay? Judges have much less impact in a civil law system, meaning a judge, when deciding a case, will open up a book, so to speak, and choose from a variety of options as to how to rule. In these cases, or in these civil law systems, people who make the laws, such as scholars and legal experts, have a lot more power because they interpret the codes, they create them, they essentially shape the direction that society will move in, right? So it's pretty interesting. You have common law on the one hand and then civil law on the other hand, and they're very different, but in some U.S. states, they have a mixture. And I mentioned this before, and now we're getting back to it. So, some U.S. states, some American states, have a civil law and also common law mixture. This is due to the European influence, the mainland European influence, so not England, not the United Kingdom, on these states when they were colonies, so before they became states. Good examples of these are Louisiana, a state in the South, which was a former French colony. So France has a civil law system. Another great example was California, a state out in the far west that was a colony of colonial Spain and Mexico. So these are little touches of civil law in the U.S. legal system. However, these states mainly have a common law system, but they do have aspects of civil law. So pretty interesting. Now let's get into the main principles of the U.S. legal system. As you can see, there is a lot of information here, but I will make it as understandable and interesting as possible. So, I referred to LexisNexis, a leader of legal information, for most of this information. So, to begin, one of the main principles of the U.S. legal system is stare decisis. This is Latin, so I hope I'm saying that correctly. This is kind of a fancy way to say precedent, right? So courts must follow precedent of higher courts within the same jurisdiction. So this essentially just means that a court is supposed to abide by a precedent established in another court when necessary. Court hierarchy. This affects the level of influence courts have on each other. So before we talked about precedent, so for example, the Supreme Court, so America's highest court, when they rule on cases, they are national cases, right? So pretty much all legal systems in the country, state, local, city, town, whatever, have to abide by them. Of course, there's a bit of give and take, right? So if these courts find issues with an overarching case, they can disagree, but it really depends. So it has to be a very kind of specific scenario. So again, we see the impact of precedent. Jurisdiction. There are two kinds of jurisdiction. The primary kind of jurisdiction we will discuss, it refers to the geographical location of courts of particular levels. So again, as you can tell, because of precedent and also the federal nature of the United States, we have all these situations where it really depends on where a court is located physically and also its strength, its impact on other courts, as to whether or not another court will have to follow its case. So, kind of interesting. Then we have mandatory binding versus persuasive authority. Affects how precedent is used. So, Again, it really depends on several factors. So it depends on the application of stare decisis. If a case is not precedent, a judge may not have to follow it, right? I know these are complicated legal terms, and I hope if you have more questions, please go to the internet or talk to your local lawyer. Everyone knows a lawyer, right? And find out more information, okay? Then we have primary versus secondary authority. So this affects how courts seek guidance. Now, by seek guidance, I mean this affects how courts determine what cases they should use for precedent or that they should draw from in order to shape a legal decision. Specifically, we're talking about two sources of law. So primary sources of law may be mandatory or simply persuasive, depending on the court. Secondary law is not actually something people have to follow, and it may not even be persuasive. But of course, again, like everything, it all depends on the court. Dual court system. I mentioned this before. The issues of federal versus local, right? So sometimes local courts have more power than federal courts. It just depends on, and I think now we're talking about the constitution of a state, or even the country. It's complicated, I understand. I don't understand how this federal versus legal stuff works out as well. Then we have, finally, the interrelationship among various sources of law. So here, I think, is where the issues between common law and civil law could play, or come to play. So I mentioned before how a couple states, and probably more, have a mixture of common and civil law. Well, who's to say when you should use common law and when you should use civil law? This is when the interrelationship comes into play. So this is where perhaps there's a rule, or perhaps there's a kind of an understanding that's not written down as to when this law should be used, penal law should be used, versus civil law versus criminal law versus, who knows, bankruptcy law. It just all really depends, right? Okay. We can talk about more kind of general principles of the U.S. legal system on the next slide. Okay. There we go. Okay, so 3 general principles. First one, advocacy and controversy between two parties. So this has to be present before a judge will see a case. There needs to be an issue between two people, two groups of people, one person versus a group of people. There needs to be a live and active issue before it'll be seen before a judge, because the judge wants to make sure there is reason for them to kind of make a wrinkle in an existing law, right? They need to make sure there's a reason for them to be opening a legal book, referring to precedent, right? Also, courts try to rule on they try to find the narrowest answer to a problem. What does this mean? So I go in, have my legal issue with my speeding, pretty cut and dry, should not have been going that fast. But I start to talk about, well, I think there's an issue with this, with the police officer because, her clothing was so bright, her car, I just couldn't really see it, even though I could see it. I have my arm kind of hurt sometimes. Like, the judge needs to know what exactly the issue is so they can find the narrowest answer, right? So the answer is whether or not I should be charged with speeding, not whether or not this police officer was doing this or doing that. Now, of course, these other issues affect the ruling, right? But you can't have a judge saying, okay, I'm going to say you weren't speeding, but also the police officer needs to change their clothing because it was too bright. Like, I know I'm making this overly simplistic and probably not that accurate, but they need the narrowest answer in order to cleanly resolve a dispute. Moving on. The courts also try to avoid constitutional problems. This is super important, right? What does this mean? So when I go, again, with the speeding example, when I go in, the judge is not interested in, because since it's a very simple issue, they're not going to be looking to make an amendment, right? The U.S., our Constitution has this is terrible, I should know this, but it has a few amendments. And it's because every time an amendment gets made, it kind of opens a box of worms, or a can of worms, right? So you never really know what could happen when you make a federal amendment, or federal rulings, because these affect all states. And then invariably there'll be someone that has an issue with it. So they try to avoid issues that involve the Constitution as much as possible. Now, of course, every time a judge makes a ruling, they are looking into the legality of it. They're looking into the constitutionality of something, but they're not trying to do what the Supreme Court does, which actually kind of opens Pandora's box in that they really get their hands messy with the Constitution. Now, let's get into players of the U.S. legal system. Another word for player is actor, so for you people watching for vocabulary, two really good synonyms, players and actors, okay? So, attorneys. There are several different kinds of attorneys. These people work to find the facts of a case and help their client win. One could say an attorney is like a coach, a very, very, very interested coach, one who you pay to help you win. So some people say there might be issues with that. I don't know. It seems to be good though that you can pay someone, or maybe they might do it for free, they might do pro bono work to help someone or a group of people win a case. So attorneys also search for facts, so they are not trying to bend the law. They shouldn't be, at least. That's against the law, doing that. And they are honest and must respect the law, right? So in addition to an attorney helping their client win, they are also officers of the court, meaning they are supposed to abide by all rules when they are trying to help their client win. Okay. What else? We have judges, probably the most famous people in the legal system. Well, attorneys might be more popular, I'm not really sure. But a judge is the really official person that has I don't know what that thing's called, but it's really cool, it makes that clanking sound. So the judge is known as the final arbiter. They act as an umpire, also known as a referee, for both sides. So a judge is impartial and biased. This means that they are not supposed to be interested in one side or the other winning. They're here listening to the case, and then they will make a fair decision on who wins and on who loses, okay? They ultimately decide the outcome of a case, and in doing so, they decide what the law is. So remember when I said before how important judges were or are in a common law system. Every time they make a decision, they impact the U.S. legal system. It's kind of amazing. So, more information about judges. Federal judges are chosen by the president, while many state court judges are chosen in popular elections. So that's kind of cool. So, for example, where I live in my state, people vote for their judge. Whereas a federal judge, so a judge that has control nationally, he's chosen by the president. He or she is chosen by the president. Finally, we have the jury system. So juries are a group of local citizens who act as fact finders in most trials. I like that word, fact finder. It's a good one. They're finders of facts. So they receive instructions from the judge as to the law and then will make informed decisions. So it really depends on the case. It really depends on the jurisdiction, the area where certain laws determine how the legal system works, but juries are often present to help the judge make the final decision. Alright, let's get on to the juicy stuff, issues with the U.S. legal system. So, these are my opinion, these are not facts, okay? This is from research I've done as a student, research I've done as a young adult now. So, it's understandable if you find fault with these, if you think my analysis is incorrect, but these are just opinions, okay? Problems with the U.S. legal system. Biases, okay? I think it's due to the fact that we have a lot of regular citizens who kind of can jump in and help to decide on a case. You often get a lot of biases that are based on people perceiving someone's race, ethnicity, nationality, their class. This is an economic issue. But researchers have also found that even time of day affects the ruling of cases. So I recall reading an article where a judge ruled, or depending on the time of the day, a judge would rule more favorably in the morning than in the afternoon. Why? Kind of makes sense. You usually feel a lot better in the morning than you do in the afternoon. I hate to say people's lives, legal lives, are affected with this, but anything's possible. So there are biases for sure that affect our legal system. Some say that we need to use more technology, such as DNA evidence, to find the truth. So, really up until recently, DNA evidence was not viable, was not possible, simply because we lacked the technology. Now that we have it, some people believe that we need to focus more on using it and other supposedly, truth-finding systems to exonerate, so to set free, or to have certain people put in jail who deserve to be in jail. So, but what else? The criminal justice system. This is a can of worms, honestly. Where to begin? So, our criminal justice system has millions of people. I think we have the largest number of people in jail or prison in the world, or at least by population, so kind of crazy. And we have even more people on parole. What is parole? Parole is where you are not in prison or in jail, you're set free, but you still have to abide by certain rules, certain laws, check in with your parole officer, go to hearings to make sure you're doing everything right. We have, I think, maybe double or triple of the people in prison on parole as well. So, very big deal. Why is this an issue? If they all deserve to be there, why is it such an issue? It's an issue because how people get into prison, how people get into jail, really depends on a lot of different factors that make it sometimes unfair. So, their race, their class, their education, where they live. Sometimes these things negatively affect people, and it makes it easier, perhaps even illegal, well, not illegal, but it makes it easier for them to be put in jail. And so some people want to change that. They want to streamline our justice system and make it less likely that people who don't deserve to be in jail go to jail. People will still get in trouble, but they won't go to jail or prison, right? Now, why do I keep saying it's such a big issue when you go to prison? In the United States, when you go to prison, in many areas, you lose many of your federal rights. Your rights as a citizen, frankly. Our Constitution has the first 10 amendments, are called the Bill of Justice, and these are rights that citizens have. So one of the issues people have with our criminal justice system is that oftentimes prisoners can lose their right to expression. They can lose the right to vote. It's often a lot harder for them to get jobs, right? So, interesting. In some areas, felons, so people who went to prison, can pay for their right to vote, which seems interesting, or they have to wait a couple of years, and then they can vote, or in some cases, if you're a felon in some states, you can never vote again. It's kind of amazing, Then also, a lot of issues we have, a lot of people, scholars, believe we have issues with the treatment of people in jail for mental illnesses, which includes drug addiction. So, since a lot of our kind of federal, national, local, so to speak, mental hospitals, that's a terrible term for it, but I can't think of anything better. Since a lot of them closed decades ago, people with these illnesses, mental illnesses, were sent to prison because their behavior was aberrant, it wasn't correct, they needed help, but no one could give them help. They couldn't afford help, their families couldn't afford help. So a lot of people in prison have mental illnesses. They're addicted to drugs, they have illnesses that can be treated or at least made better, but there's no framework for that, so they're just in jail or prison, which is really unfortunate. So that's an issue. People ask, why don't we have systems that treat these people instead of putting them in jail, which often can make them even worse. Some say it's inhumane. And finally, in addition to the issues with our criminal justice system, there's the pressure to make people plead guilty instead of standing trial. What does this mean? So a lot of people that are convicted or about to be convicted for kind of low-level issues, so maybe drug possession, maybe robbery that was not violent, something like that, they're often encouraged to, oh, just when you go to see the judge, just say I'm guilty. They are guilty, but sometimes it's possible if they were to stand trial, if they were to kind of work within the legal system, they may not have to go to jail. They may not have to pay such a large fine, right? But there's kind of this encouragement to just get people in and just make it easier. Some of the workers in the legal system, just so they don't have to deal with these people. So you have a lot of people, we call them non-violent, low-level offenders, who were in prison and jail when maybe they could be on parole or in a kind of rehab system. So these are also good questions. So springing off of what I was talking about with getting people to plead guilty and just kind of pushing them into prison, is our prison industrial complex. This is a big phrase. What does it mean? This essentially, to speak crudely, I suppose, means getting money for locking people up. Where exactly does this happen? It could happen in really all levels, from local to the national level. Local level might be, and there's actual evidence of this. There are many books, resources out there, in case you're interested. A local example is police forces, right? So say I live in a city, and my police force doesn't have a lot of money. How can they get money? How can these officers who are supposed to uphold the law get money to feed their families? These are real issues. So there's a law passed by, say, a local government that says, well, if you guys arrest more people, you can keep more of that money when you arrest them. What do? These men and women have to feed their families. They want to make sure their jobs will be there the next day. So they begin to arrest more people. They begin to stop more people for driving. They begin to do more searches of people, of their bodies, of their cars, of their homes, just to make more money. Also, this could happen in jails and prisons. So a lot of our prisons are run for profit, and I don't have enough knowledge about for-profit versus public prisons, so I'm not commenting on that. But I will comment on the fact that often prisons would need a certain quota to stay open. So it's kind of run like a business. So you can begin to see where there might be some issues with that. Then also, the federal government, the U.S. federal government, in past, and I believe maybe still does, will give money to, or give certain weapons, maybe even military-grade weapons, to police forces in order for the government to kind of get rid of them, but not without throwing them away, not without wasting money. So I'm not saying that there are issues with everything in our criminal justice system, but there are certainly problem areas that we need to work on. And a lot of it is, paying people, officers of the law, appropriate wages. It is giving people who are convicted of maybe low-level offenses a better way out than prison. It might also be establishing hospitals, things like that, for people with mental illnesses. So there are several ways we could tackle this very cyclical issue of putting people in jail and also kind of criminalizing the people that put them in jail. So we have a lot of issues with that, and I think we can work them out if we try. So, in conclusion, that is my presentation on the U.S. legal system, and I hope you understood everything. I hope you enjoyed it, and I also hope you're walking away with a new set of vocabulary. So, thank you, and have a nice day.